Under the common law, a landlord didn't have a duty to relet the premises after a tenant defaulted on the lease. However, some states today require a landlord to make a good faith, reasonable effort to relet the premises after default to mitigate damages. In Ruud v. Larson, the North Dakota Supreme Court considered whether a landlord made a good faith, reasonable effort to relet the premises when he or she didn't hire a real estate agent and increased rent. In 1966, Arthur Ruud leased commercial property he owned in Fargo, North Dakota, to Raymond Larson for a 10-year term. Larson then constructed a building on the property where he operated a car wash and gas station. After the lease was up, Larson agreed to another 10-year term. But in 1982, Larson defaulted by failing to pay rent or real estate taxes as required by the lease. Subsequently, Ruud sued Larson in state district court for breach of the lease. Before trial, the parties agreed to stay the action after Larson's corporation filed for bankruptcy. The bankruptcy court later approved the sale of nearly all of the corporation's assets to Charles Luna. Larson then proposed subletting the property to Luna, with Larson agreeing to pay the taxes in arrears, and sent Ruud a proposed sublease agreement. But Ruud rejected the proposal, redrafted the agreement, and sent a revised version with a cover letter emphasizing that his offer was contingent on Larson's agreeing to pay the taxes in arrears. In response, Larson made a counteroffer to buy Ruud's land or sell the building on the land to Ruud, which Ruud rejected. Eventually, Ruud took possession of the property and showed it to prospective tenants without hiring a real estate agent at an increased rent. But Ruud couldn't find a new tenant. After the stay was lifted, the case went to a bench trial, and the district court found in favor of Ruud. Specifically, the court found that Ruud made a good faith effort to sublet the property and mitigate his damages. Larson appealed to the North Dakota Supreme Court.